to the newly named show, Making Sense of Investing with Court. This was all through a social media contest, and the name came to be from that contest. So I thank everyone who contributed in helping to name our show. I am here and joined today by Chris Muvdi, who is a partner at Masano Bradley. And we are going to be speaking on a really important topic, and one that I frequently get asked about, and he does as well. And it's really around estate planning. So, Chris, do you want to just introduce yourself and maybe your background a little bit and how you work with clients, and then we'll get into some of the questions?
Sure. Thank you for having me. Thank you for the introduction. As was said, I'm a partner at the law firm Masano Bradley. We're a general practice law firm locally here in Wyomissing. I've been at Masano Bradley for approximately 10 years. We, as I said, we're general practice. We handle, everything from mergers, acquisitions to general mom and pop estate planning. So we have somebody at our law firm who can handle most every legal matter that comes about.
Wonderful. I know I personally have, engaged with you, and we've also sent several clients your way, and, it's always been a great experience. So we're going to just go through, some of the popular questions that were asked and speak to those. So I guess the first thing is, nobody wants to talk about the inevitable, but it's irresponsible not to.
Yeah.
So we're going to go there today. What are the absolute must-haves to really have in place to make sure that your family is protected?
Sure, and I think you nailed it. It's a morbid topic, and people generally don't want to bring it up, and that's why I have people in their 60s, 70s coming in to see me for the first time with no plan in place whatsoever, no documents, nothing. So I sort of need to walk them through the essentials. And in my opinion, for a good plan, there's 3 essential documents that everybody needs. And all 3 of them serves a different purpose, and they're each important in their own regard. First, I think everybody needs to have a will in place. And I think, generally speaking, everybody has an understanding of what a will does. In its most simple form, it passes assets when you die. Where do you want your things to go when you die? And that's assets that are probate assets that pass within your will and don't pass otherwise. So that's the first. And we can get into there's other things that you can do within a will, like naming a guardian for small children, funeral instructions, if you so choose to have that in there. That's the first document. The second document that I think everybody needs to have is a power of attorney. Within a power of attorney, you can name an agent who can manage financial affairs for you. If you choose, you can have that person control medical decision making. So it's a very powerful document, and you can limit it. You don't have to make it extremely broad if you don't want to. I recommend that you do, but you can limit it. But effectively, that document gives whomever you name as your agent broad authority to do things for you. And we generally speaking want it to be broad. And the reason for that is, if you ever become incapacitated and can't make decisions for yourself, the alternative to having that document and that person in place is to file a guardianship petition with the court of common pleas if you're here in Pennsylvania. And that's a lengthy, expensive process. And the simpler thing to do is to execute this document, the power of attorney document, when you had capacity, so it's in place for that, oh boy, I got hit by the bar bus event.
Yeah.
And lastly, in my opinion, the third document that everybody should have is a living will. A living will is truly an end-of-life document. What type of treatments do you want if you're terminal, you're going to die, and you cannot make medical decisions for yourself? You have the ability now to select treatments that you either do or you do not want if you're in that circumstance, so that there's no confusion. Also within that document, you have the opportunity to appoint a surrogate or essentially a decision maker at the hospital that a doctor is going to look to make end of life decisions. It's important because otherwise, and I've seen this scenario where family just doesn't know what their loved one wants. So this document makes it extremely clear. So in my estimation, those are the 3 vital documents that I think everybody needs to have in the estate planning realm at its simplest form.
And I would argue that it's regardless of age. I mean, if you own a home or you're, living with someone else or you have small children, that's even more of a reason that you want to have these things, in place. Some people think I don't have any assets, but that's not really, it's not just about covering the assets. It's about covering, your wishes as well.
Yeah, agreed. I don't care what age you are, how much money you're worth, you should have a will in place. And it doesn't need to be complex. We don't need to go overboard, but everybody should have those 3 essential documents in place.
And maybe you can speak to the difference of just, some clients come in and they say, well, I have, my spouse named as the beneficiary on the account. Do I really need a will? Can you speak to that?
Yes. Just because your spouse is on, an account, what happens if, God forbid, you're both in an accident and die? What happens then? So we're trying to plan for worst case scenarios when we do these things, and multiple events and eventualities in that document.
Going a couple layers deep.
Correct. So yes, so long if you have a spouse on a certain bank account, in theory that asset should pass to them without having to open an estate, but that's not always the scenarios that we run into. So we're trying to plan for multiple events.
Yeah, and I think the other important thing to note is that when someone passes, that power of attorney is done. That document no longer exists. I do frequently get that.
Yeah, I get that all the time.
Yeah.
I was named the agent in the power of attorney. I explain to people, well, that document dies with the person that created it. Mm-hmm. So once that person dies, power of attorney ceases to exist, and the person that you have named as the executor in your will then assumes all of the roles, essentially, that the power of attorney could have performed.
Great. Another one that I get all the time, it feels like, how do I protect my assets from the nursing home? And it's a very loaded question, in my opinion. So I guess the first part of this is, what are ways, that you can protect your assets from a nursing home, and is there such a thing?
Yeah, it is loaded. It's not easy, okay? Yes, you can create, effectively an asset protection trust, and put certain assets into the trust in order to try to prevent those assets being looked at by, the Department of DPW when you do apply, or a loved one applies for Medicaid, okay? Generally speaking, you have to spend down your assets to a certain threshold in order to even apply for those services. So, I do have a lot of people that come into me that say, can we shield a big one is the house.
Yes.
Okay, can we shield the house from being considered in that calculation? And yes, in theory, you can create an asset protection trust and put the house into that trust while you're alive and well and don't need services. There's a lot of pitfalls with doing that, okay? Number one, you have to do it within a certain period of time. If you do it within 5 years of applying for services, well, it's still going to be calculated. There's a 5-year look back for any transfers that you made, gifts you made to loved ones or whoever. The department is going to consider that, that you did that within that 5-year period in order to avoid it being within the calculation, okay? So timing is a big issue that I see with people trying to accomplish this. Second issue with the trust, there's certain assets that you can put into the trust and certain assets that you can't. One of the assets that you can't put within a trust is a retirement account.
Right.
Okay. And nowadays, a lot of people have the bulk of their net worth in retirement vehicles, and you're just not going to be able to put it into a trust. Can't do it. So, you know, the benefit of this type of trust, you know, sort of chopped in half when you consider that.
Because really, if you're applying for Medicaid services, which I will say is not the ideal place that you want to really be spending, you know, if God forbid you were in that situation and needed to go into a facility, you don't really want to be in a Medicaid facility.
No.
So, you know, those are definitely things to think about. I know we have some tools on our side on the insurance planning side, and I've spoken to many clients about a life insurance with a chronic illness rider, a long-term care rider, where we advance the death benefit to be used towards long-term care expenses. So at some point that death benefit will be used, whether it's, you know, in a chronic illness case or whether it's at, you know, someone's passing. There are tools that are out there, but those are just some things that I think are important.
You know, another issue with the trust, the asset protection trust, you can, you know, the assets that you put in. Again, you need to consider the fact that there is going to be this look back period. So if you place the assets into the trust, you know, 3 years before you need service, it's all going to be considered. Another issue, commonly, once you put the assets into the trust, it's irrevocable. You can't then take it out. So you lose control. You need to name a trustee to manage those funds. It can't be you, should not be a beneficiary. So you're naming someone and you're losing control of that asset. So if you need it for some other purpose, you won't be able to get after it.
Yeah. And that, I guess, will lead me to the next thing. I'll have, you know, clients say, should I put my adult children's names on my home? Again, another loaded question.
Yeah, absolutely. And I'll give you a very a real life case that I'm dealing with currently. Mom and dad, for estate planning purposes, put son and daughter-in-law on the deed to their home and named them as 50-50 owners. They did it again to try to avoid Pennsylvania, you know, a large piece of Pennsylvania inheritance taxes,
which is 3.5%.
For lineal descendants, it's 4.5%.
4.5%. Okay.
So they did it for estate planning purposes, and everything was honky dory at the time. And 10 years goes by, and now they've had a falling out, and son and daughter-in-law now want their 50% share that was gifted to them. So we're currently in the midst of litigating a partition action. So that's just one of the pitfalls.
Yeah. And those are things that you don't expect to ever happen.
No, they certainly didn't at the time that they did this. And another pitfall with putting a loved one, not a spouse, on a deed to a property is what happens if that spouse gets divorced? Mm-hmm. Then you've now made their interest in your property that you live in subject to equitable distribution in a divorce. What happens if your loved one who you've put on the deed to your house gets into a horrible car accident that's their fault? You've now made it subject to creditors, and you could lose your home. So generally speaking, I try to talk people out of doing anything to that effect for those very real life reasons.
Yeah, and I know we have seen some of those unfortunate situations happen as well. Well, I think, Chris, that kind of wraps up today's segment. We're going to definitely be continuing to have this conversation in the months to come. If any of you have any questions and want Chris's information, I'll be happy to share that. But thank you so much for your time today and talking about this topic that a lot of people don't like to address, but it's really a necessary one. Thank you for your insight. And to everyone else, thanks for listening, and we will see you next time.